The most interesting case I had this year involved a cooperative, which had a very large lien filed against it for work done in an apartment that was combined by a tenant shareholder who purchased the apartments already combined, but then decided that he and his wife, who owned the apartment, wanted to improve it to the tune of almost $2 million and decided not to pay to the tune of almost $1.8 million on those renovations. The contractor filed a lien against the building, of course, claiming that the approval of the co-op through the alteration agreement and by signing the forms was sufficient to allow them to file a lien against the building under the lien law. And you can imagine how unhappy the board was to find out that a $1.8 million lien, which subsequently got revised down to $1.25 million, $1.25 million, in fact, was the true amount that was claimed. I started proceedings immediately against the tenant shareholder for failing to remove the lien within 30 days. And also the banks, which had loaned money, started foreclosing. And predictably, the spouse, the wife, filed for bankruptcy. And then we got involved in bankruptcy issues concerning priority of liens and the bona fides of the contractor's lien, and all of the issues involving what would constitute consent under the lien law, because bankruptcy courts use the lien law, to figure out if the lien was properly filed against the building, and if so, in what amount. The case finally got settled, but not after several trials and the eviction of the tenant shareholders. Interestingly, the consent under the lien law is not just the consent of the board to plans or the signing of the alteration application to file with the Department of Buildings. The courts, at least some courts now, will take a deeper look and check to see whether or not the co-op was simply protecting its interest in the building by having the tenant shareholder sign an alteration agreement. And also they didn't view the signing of the Department of Building forms as necessarily the consent. And in our case, the court made it quite clear that since the board had only reviewed for things like, are other tenant shareholders going to be disturbed? How are they affecting the pipes and electrical and building systems generally? And the board expressed no opinion whatsoever concerning the design and did not benefit in any way from the design and construction in the apartment. The court found that the consent that we had given for filing a lien under the lien law had not been given. That was very important because it allowed us to negotiate a settlement of the case overall, which moved the lien off of the building and onto the shares by court order, which is a whole other interesting question in law, because can you file a lien against shares of stock under the lien law? This judge was fine with that, and I was too, because my client, the co-op, got the lien removed. We worked out a deal that once we had evicted the tenant shareholders, we were able to recover all of the amounts that were due to the client, the co-op, for legal fees, for arrears and maintenance, for all kinds of expenses that were incurred in just trying to deal with these liens. And if I had to give any co-op some advice about this, I would say, don't just go blithely signing these papers. They're very important, and make sure that they're understood both by you and the tenant shareholder. Make sure that the tenant shareholder is doing work that they've described. In this case, they did a lot more work than was described, and obviously incurred a lot more expense. And just know that under certain circumstances, if you get too involved in the design, or it appears as though the co-op is not just protecting the interests of other shareholders and the building generally, that you may be responsible if a lien is filed against the building and may have to go to the apartment to get paid back for money that you spent. So it's important stuff. Pay attention.